Go ahead and bring in our guest for this hour to discuss. Joining us now from Santa Fe, New Mexico, trial attorney John Day. John, thank you so much for being with us. Nice to see you again as we review this case before court actually starts live there in the state of Washington. So the state has been presenting this body camera footage of the attack, of the aftermath, of the chaos and the aftermath. We heard an eyewitness there talking about the situation and what had transpired. What's your takeaway from this?
Well, thanks for having me. This is really compelling video that the jury is getting to digest, the concept of a father and mother charged with an attempted second-degree murder. The prosecution claims it's an honor killing. And the video shows us not only the earlier video that we've seen, the cell camera video, but the fact that there's a father committing violence against the daughter, and the jury is digesting this. And what the prosecution needs to do if they want to get to that second-degree attempted murder charge is convince the jury that this wasn't just an assault, this wasn't just a parental intervention that went wrong, that this was something more, that this was actual violence against their daughter that almost led to her death. And we've got all the medical testimony that the jury has heard about the physical damage to her. So the prosecution is going to hope that this video is sitting with the jury, and the jury is saying this is not a normal dysfunctional family situation. This is something much worse.
Yeah, you have to wonder, because from the testimony that we have heard so far, you can easily assess in your head that this is parental intervention that did go wrong. You then see the video, you see how aggressive the father is being. Even you heard the officer say he came up to her, he put her in a chokehold because she wasn't listening to go home, and the officer says, yeah, it was a little bit aggressive. It is aggressive.
Right, and even when he's sitting handcuffed in the police car, he's still trying to control the situation. He's not responding to the officer, he's trying to bark commands at his wife. The jury gets a sense, certainly, of the level of aggression. And for the prosecution, they've got to sustain that, because otherwise the jury during deliberations might say, you know, this was violent, this was an assault, this was an attack, but was it attempted murder? And that's the threshold the prosecution has to cross.
Absolutely, John. Thank you so much. Coming up, responding officers begin talking to Fatima Ali's mother and sister. We'll be right back with more body camera footage. That's coming up next. Still with us, trial attorney John Day. Okay, John, we've gotten some questions in on our YouTube feed. Many people are wondering this, and this is one of the questions. If the attempted murder was for an honor killing, why can't the correct terminology be used so that the jury actually understands completely what was happening? Now, John, the judge had made a ruling here that certain terminology cannot be used in this case, saying that it would be too prejudicial, so you can't use the phrase honor killing. Can you kind of talk about how that works in a court system? When you try a case, there's certain words, there's certain things that actually can't be said. Here, the judge said that was too prejudicial, which I think a lot of people are having trouble with.
Right, Kelly. Well, honor killing is not a term that's included in the statutes, the jury instructions. It's a loaded term, and while we may know, culturally or socially, or know about the concept of honor killing in various societies, things like that, it's not something that the prosecution has to prove. And the judge here making the right call, saying if we use those terms, it elevates that loaded expression to something that the jury doesn't necessarily need to consider and could be so prejudicial. So keeping that out of the jury's view, keeping the words honor killing out of the case, it's a way to protect the defendant's rights to a fair trial. And it also keeps that really loaded expression out of the courtroom when it doesn't have to be in there in the first place.
And John, what about this one? This was another question. What do you think this case will say, someone wrote in, about understanding how someone's cultural background can influence a victim's experience with the court system? Obviously, we are here in the United States. We are governed by the laws of the United States. We're not governed by the laws of another country. So here, when you're in the United States, you have to follow our laws. But some people are wondering, you bring all these different cultures here, how does that work with the court system? I know we only have about 30 seconds.
Right, great question. You know what? This concept goes back to Romeo and Juliet. It's a Shakespearean concept. Parents unhappy with the daughter's boyfriend, it turns to violence. Luckily, in this case, no one gets killed. But the courts don't recognize the cultural differences. They just recognize the concept of an attempted murder and assault.
Yeah, exactly. All right, John, thank you so much for your excellent insight. Now, coming up, we'll get you into that Washington courtroom where testimony resumes at any minute in the attempted honor killing trial. We're coming right back.